Good evening, everyone. My name is Pooja Dwivedi. Welcome to my class. Today, we shall talk about the evolution of abortion laws and the acknowledgement of the rights of an unborn child. This is a very interesting case that I'm going to tell you now. From the perspective of GS Mains paper second as well as fourth, it is important to understand today's topic till the very end. By the end of this segment, you will have a lot of clarity. Other than this, if you have any questions regarding this examination, do talk to me on my Instagram, follow me on my threads, and if you want the notes of the classes that I take, please do be a subscriber to my Telegram channel. That is by the name of Pooja Dwivedi UPSC. Now, just get a brief background of the entire situation. A 27-year-old woman who is already a mother of two. She has been pregnant for 26 weeks. She goes to the court, asks for the permission to medically terminate or abort her fetus. The AIMS prepares a report suggesting that the fetus is viable. That means the fetus has a high chance of surviving after being born. So the Supreme Court decides that the Supreme Court cannot go ahead with the killing of the fetus because her heart had already been formed. Formation of the heart makes the fetus a living being. The Supreme Court did say that it is the onus is on the mother to either keep the child or give the child up for abortion. Even the center intervened, saying that we cannot allow this pregnancy to be terminated because it is beyond a threshold. I will talk about the threshold as well, 20 weeks and 24 weeks in certain cases. But if there is a need of psychological counseling or any other sort of assistance, the center is ready to do so, even for adoption. So the entire thing that we have to understand over here is the evolution of the law, the abortion law. All right. So there was a lot of going back and forth. But now the Supreme Court has made it clear that they are not going to go ahead with the abortion. Earlier, on 9th of October, Justice Kohli and Justice Nagaratna, they made a decision. They were okay with termination of the pregnancy by the 27-year-old woman. But just after that, just after few moments of that, the AIMS report came suggesting that the fetus is viable. Fetal viability is one of the biggest things whenever we are going to discuss abortions. And fetus is viable, according to that report. There was a split in the judgment. Justice Kohli said she is not in favor of going ahead with the judgment of terminating the pregnancy because the fetus is viable. The 27-year-old woman or the mother, we have to talk about her now. Is there any sort of abnormality that is going on with her, specifically with respect to mental agony and the body? Now, on October 13, a 3-judge bench of Justice Chandrachud, Chief Justice of India, of course, Justice J.B. Pardiwala and Justice Manoj Mishra, they took up the case and asked AIMS to study if the fetus is suffering from any substantial abnormality, if the medicines that the woman is taking would have any effect on her carrying her pregnancy further. But nothing was found of such record. Then, the final verdict that came, it is a very balancing verdict. Just understand it from the perspective of GS Mains paper 4. We have to balance the rights of the unborn child because the mother has been represented by her lawyer. There is nobody that is representing the unborn child. How do we balance the rights of the child? Fact of the matter remains, it's not just a fetus, it has now become a living, viable fetus, and if given birth, can survive outside. If delivered now, it will have serious medical issues. The mother will of course go through serious medical issues because medically it is not advisable to abort the pregnancy post 24 weeks. If certain cases are there, then it's okay. In certain conditions, Supreme Court has favored for abortion. We will talk about that as well. Moving on. Now, if we talk about abortion in India, generally, let's look at the statistics. According to a survey that was conducted from 2015 to 2019, it was found out that every year, India noted approximately these many pregnancies, out of which approximately these many were unintended, that led to these many abortions. That means more than half of the unwanted pregnancies were aborted. That means 5 to 13 are caused by unsafe abortions. Because anything, if it is not regulated, if it is not stigmatized, if it is stigmatized, if it is not normalized, of course, people, specifically women, will go to such quacks and doctors who will, for a meager amount of money, will play with the lives of both the mother and the fetus. So 5 to 13% of the deaths are caused due to unsafe abortions. Now, in order to ensure that these kind of practices don't go forward, India came up with the Medical Termination of Pregnancy Act in 1971. We were very well aware of the kind of situation India had entered into. We knew that criminalization of abortion and the reproductive rights of the woman should not be anymore like this in our country, because before the MTP, the Indian Penal Code, through its sections 312 and 318, used to deal with it. It was more of a criminalization of abortion rather than humanization of the abortions. And it also failed to make any distinctions between wanted and unwanted pregnancies. So that is why the Medical Termination of Pregnancy Act of 1971 came into existence, which permitted a licensed medical professional to perform abortion. That means to safely and medically, abort a baby, or get, we can call it, yes, abort a baby, that is much ahead of its meaning, through specific predetermined situations. That means if there is a case of unwanted pregnancy up to certain weeks, if there is a case of abnormality in the fetus or even in the mother, then also it can be done. And that was a health measure, very humanitarian in nature. It wasn't criminalizing it. But we have to know about the features of it, because we will compare it with the 2021 amendment. There was a permission to terminate pregnancy under section 3 clause 2 if it did not exceed 20 weeks. Opinion of one doctor was needed if 12 weeks of conception was there, and two doctors if it is done between 12 to 20 weeks. Then it is done only when the continuance of the pregnancy would involve a risk, the life of the pregnant woman, to the life of the pregnant woman as well, the risk, the discovery of fetal abnormalities, that means if there is some sort of issues with the baby in the womb, and when the child will be born, then also there will be abnormalities, then also it can be aborted. Then immediate necessity to save the woman's life, or if the pregnancy is causing grave injury to the woman's mental as well as physical health, that could be due to rape or the failure of birth control measure. Then a married woman can terminate an unwanted pregnancy too, but no such procedure shall be carried out on any woman without her consent. That means forcible abortions were not allowed. And to keep that safe in nature, in 1994, the government also introduced Preconception and Prenatal Diagnostic Techniques Act, in which this was done to avoid the abuse of the MTP Act for sex selection, so that people couldn't select the sex as in when they knew the sex, either it was a boy or a girl. Generally, of course, common practice is there in many Asian countries, including India, to uphold the birth of the boy rather than a girl. So female feticide started to take place after that. But the government brought into existence in 1994 this particular act to penalize anybody who is using these kind of techniques, modern techniques, to do female feticide or some kind of feticide. Even it could be for boys, but of course not. So to prohibit prenatal diagnostic techniques for sex determination, and to regulate prenatal diagnostic techniques for detecting genetic abnormalities and other disorders also, it was there. And anybody who violated this particular act, 5 years in jail was there, apart from monetary penalties. Moving on. Now, the 2021 amendment was a watershed in the abortion law evolution. Why? Because as the time changed, the social realities changed. And when the social realities changed, it was of course necessary by the government to change the laws. Anything which cannot be banned has to be regulated, so that it could be more, better for the women, as well as for the societal structure, for the family structure. So it permitted abortion up to 20 weeks. Here, there was the necessity of an opinion by one medical practitioner who is registered, of course, abortion was also allowed up to 24 weeks in certain cases, according to Rules 3B of the MTP rules. When there is a change of marital status during the ongoing pregnancy of the woman, then 24 weeks threshold will uphold. If there is a case of survivor of rape, victim of incest, or there is a vulnerable woman, that means who is differently abled or even a minor. So here 24 weeks of threshold holds, but for others it is up to 20 weeks. And also this law is very progressive in nature because, as I told you, the social realities are changing. Similarly, the law said now it is fine, it shouldn't be stigmatized. Sex outside of marriage should not be stigmatized. Why? Because unwanted pregnancies do happen by sex outside marriage. So in order to regulate those kind of cases as well, this particular amendment replaced the word by any married woman or her husband to any woman or her partner. That means any pregnancy that is happening outside the wedlock was also brought into the ambit. But important judgments are, of course, can be asked in your examination, and also Supreme Court's entire involvement in this law will also be asked. So make sure you know the important names of the cases, such as Suchita Srivastava and another versus Chandigarh administration, in which the Supreme Court said a woman's right to make reproductive choice is also a dimension of the personal liberty that is upheld under Article 21. In Z versus State of Bihar of 2018, the Supreme Court saw that even after passing the proper judgment to terminate abortion, the administration was not doing so. So they rebuked the negligence and carelessness of the authorities in failing to terminate the pregnancy as permitted by law. Now, in the Mamta Verma versus Union of India and Sarmishtha Chakrabarti versus Union of India, both were in 2018. In which the Supreme Court upheld the termination of post-20-week pregnancies because they were going through agony, mental agony for it. Then Sheikh Aisha Khatun versus Union of India in 2017 and Vaishali Pramod Sonavane and another versus Union of India 2019. The pregnancy can be terminated after 20 weeks if there is a substantial risk to the child. Once the child, if he or she is born, is going to suffer any kind of handicap, either physical or mental, then the child can be terminated, aborted. Then XYZ versus State of Maharashtra in 2021, a minor was allowed to terminate her 26-week pregnancy at her 26th week, and that was because of her socioeconomic condition and the condition that she was going through mentally by carrying that pregnancy further. Now it was a watershed again in 2022, September 2022, when there was an acknowledgement of rape that is marital in nature, rape that is having a rape that is being occurring inside the wedlock. When a husband rapes a wife, that has also been acknowledged. Judicial recognition to the marital rape for the purpose of abortion. This was really important to be acknowledged because people do not believe in India that this could also have happened. And the MTP rules allow women, married women, to abort up to 24 weeks on account of mental anguish, rape and health complication, but unmarried women could not do so. So the Supreme Court stepped in and said that why do we discriminate on this basis? A woman's right to her bodily autonomy, a woman's right to her reproduction, and a woman's right to practice her liberty in a way that is balancing in nature has to be upheld even if she is married or not. Okay, so this was the evolution of the entire situation. I hope you understood it from the perspective of this examination. Thank you so much for watching.